Hello, this is Tony Gangale. I'll be discussing the book. So the book started off regarding the disputes the Union Chiefs had with the Food and Drug Administration. The case in its face is illogical. It seems to conflict with well-established federal law and or circumventing federal law. And what I mean by that is, so the government imposed a zero tolerance for Listeria mono in the processing area to prevent contamination from occurring. Concurrently, the FDA reported 12% of the commercial raw milk supply contained Listeria. So it's illogical when federal law allowed natural Swiss cheese to be made with raw milk. Additionally, several days after the June 16th order, appears that the FDA knew that the order that they created or the court had created was a virtual impossibility. So there's affidavits regarding that. And further, when you think of if there's an impossibility, then how would you be able to explain the successors and any and all the persons in active concert and participation with them after this order? Particularly when you consider that they were supposed to be consultants by the FDA, independent laboratories, that the FDA had to notify the defense in writing that they appeared to be compliant. They're supposed to have specialists and stuff. So if this order is not possible, it would seem that there are some serious shady things going on, because it would be seemingly impossible for them to sign off or verify these particular things. So that's kind of how I started off the book, because there's just a lot of issues. What I'll discover is, when I'm going through the paperwork, I started digging into stuff, is I discovered that the statement of fact, it appears to be absolutely incorrect, and they improperly named individuals in this action. So you go back and you wonder, so it appears that they conducted an entire federal trial with the wrong individuals named, and I'll further discover that the plaintiff, U.S. attorneys, and the court knew that there were these issues before they had this trial. So there's serious issues that the principal adverse individual whom the judgment would appear to be against, or the issues, did not participate in these proceedings, and that would create a whole bunch of legal rights and the validity of the order. So you'll further discover, and I'll go through this very quickly, is it appears that they ignored documented evidence. Further, that the defense attorneys had described the roles of the parties that they had named in filings, as well as the attorneys informed the plaintiff that there was improper parties named in this action. It goes further in docket number 14, where there's a case management. It provided the FDA to go to the facility, and also the U.S. attorneys that the defendants will make the proprietors available for depositions. So it's inconceivable for these events to have occurred. Further, it appears that they were aware of all this stuff and they refused to acknowledge or examine these issues. More is Rule 62 or 602 requires the need for personal knowledge. So people testifying to facts have to have an opportunity to observe certain things. So with the people that they've named, it appears that they wouldn't have had personal knowledge of facts. The declarations they put before the court, I believe there's about 100 witnesses that could testify or would have direct knowledge or interaction with the parties to determine that the declarations that they put before this court is absolutely incorrect. Additionally, the people in red would have knowledge of certain facts that would seem to be in dispute with what's presented within this federal court order. So there's quite a few people that could testify that these declarations, or there's something wrong with these declarations. Clearly, this was not a mistake by the individuals. This was not an oversight. This was not misjudgment on their part. It was clear that there was an intention by the government, and it was told to me and another, and they explained what they were doing. So none of these things were mistakes. It was clearly intentional, and I believe that there are absolute issues that there were government misconduct, and I believe they raised to the level of federal crimes. So not only was there improper parties named in this action, it clearly is inconsistent with the law that was existing, and the law did not change after this order. So it's disturbing on that hand. There's also the right to be heard, the code of candor by U.S. judges, a judge should afford the duty, allow every person with a legal interest in the proceeding, the person's lawyer, and the full right to be heard. And that's clearly not what happened in this case. I believe that there was government misconduct. I believe it was willful. I believe it also violated the Administrative Procedures Act, or they're somehow circumventing federal law with the right to use raw milk and age it for 60 days, as well as the policies of the zero tolerance policy. I believe that there's serious issue of the candor to a tribunal, Rule 11, motions and pleadings before the court. It is clear that the U.S. attorneys had knowledge of facts, and they clearly did not investigate or even inquire, or they're skewing things, or there's clearly issues that they did not examine the facts that they put before the court. And the logic that of the case just does not make any sense. Further, there's issues that I believe that's in an impossible order, or virtually impossible, and the FDA themselves, before the judgment, made statements to parties stating that. Further, there's issues of whether that June 16 federal court order, if it's valid, and if there was equal application under the law here. So I'm just going to go real quick. So it's clear that they ignore documentary evidence, and these are the FDA officials themselves, I believe, filling out the paperwork here. So it's clear that they had knowledge of certain facts. You'll see within docket 8, docket 11, and docket 13 information that was presented to the court. You'll also see docket 13. Here you see the case management, that the FDA will visit the facility. Also, you'll see defendants will make proprietor and managers available for depositions. So the FDA would have clearly had the ability to verify the information to see if it was correct. Further, the U.S. attorneys had the opportunity to depose people, interrogatories, and whatnot before this case proceeded, and it appears that they did not do that. And you'll see the memorandum in opposition to defendant's motion to dismiss. The FDA visit was on June 16th through the 19th. They filed that on May 24th. So it was after the FDA's visit that they filed these. So it's clearly they had opportunity to examine what the hell they put before the court. You'll further see, to my knowledge, from the case management, I don't know if the court ever ruled on the motion before they conducted the trial. So you'll see the motion in opposition, and the order came down, or the findings of fact, of June 16th. So I don't know if there was ever an evidentiary hearing or analysis of the facts that were presented to the court. There's multiple issues in the response to the motion to dismiss. It appears that they had no further investigation to verify what they were putting before the court, and I believe that's an egregious act of misconduct, and I believe it violates Rule 11 of them certifying what they put before the court. And clearly there appears to be evidentiary evidence to conflict with what they were putting before the court. Federal rules of evidence, and the purpose is to seek the truth and ensure that just determination of those facts. Clearly that did not occur here. So this was no mistake by these individuals. It's clear that they had knowledge of multiple times, so there would be absolutely inconceivable that they conducted an entire federal trial with the wrong person. That this could not be unintentional. They knew what they were doing. They had a purpose. We know what that was, and disregarded everyone's right. Moreover, is that this particular matter made news, so there was broadcasting information of the general public that they would have had knowledge of certain facts. There's information that was within the broadcast that would conflict or raise suspicion of what findings or what was presented to the court. The most disturbing here is that it just does not seem possible. This order, it seems to conflict with federal law. So in the docket number 26, the findings of fact, you'll see that this facility here, the defendants have established and implement adequate methods, facilities, and controls for receiving manufacturing, preparing, packaging, distributing, and holding articles of food in the facility to ensure that the articles of food are not contaminated with Listeria mono, other pathogenic bacteria. So what's most interesting about this order is to Listeria mono, it forbid other pathogenic bacteria. Now let's rationalize this. Is federal law provides that a manufacturer could use raw milk. Concurrently, the FDA surveys have established that there's 12% of raw milk in the commercial milk supply. So within these laws, it does not seem possible that you can have the right to use raw milk, or they're attempting to circumvent those rights or privileges. So something just does not fit here. And here's an affidavit by Milton, the compliance officer of the FDA Cincinnati office, makes this stated it was going to be virtually impossible for Mr. Gangale to resume his Swiss cheese manufacturing operations. Again, this is before the judgment is entered. I believe came down on the 23rd. So before this order was, the judgment formally within these proceedings, the FDA knew certain facts. So that should be very disturbing to all. Further, when you determine that the television reports and things that they were stating publicly, it seems to conflict with what they said privately. So this should concern everyone of just the outrageousness of what the federal government had done. If you read the order, there was pages of mandates. So if you were to have zero Listeria mono within your facility, and you examine what 12% of the commercial milk supply has it, that just bringing in milk of Listeria, you add in that you were to have other pathogenic bacteria, it's a near 100% on day one that you could not comply with this court order. Anyone signing off on this, so if you have an independent laboratory, the FDA saying that they specialists that we're supposed to examine, is from day one, you would go to the bacteria estimates of each producer that you have. You would examine those records, and it would automatically tell you if they're in violation or not. So I believe, and this order was under threat of civil and criminal contempt. I find it impossible that this order was complied with. And if that's correct, as how does the government explain, or how did the people explain these facts? So I believe this order is impossible. I believe that there were due process violations here. I believe Rule 65 of the injunctions and notice to the adverse party was not complied with. I believe the filings were misrepresented, and I believe that they did not do an inquiry before they submitted those. The candor to a tribunal, I believe there's just countless things failing to correct the record or misrepresenting facts, the controlling legal authority, just numerous things. Again, I believe that there was due process violations here. I believe the oath of office, the right to be heard, the code of conduct of judges, the right to be heard, I believe that was violated. Further, I believe that this order is void. I believe non-joiner of a necessary party impacts the validity of the legal proceedings. And I believe that there is numerous people that can testify that there's something wrong with the declarations that were submitted to the court. The Department of Justice, their mission statement to ensure fair and impartial administration of justice for all Americans, issues a fair trial. So it's been difficult even getting the entire trial record. I attempted to obtain the records that I have, or certain critical documents that I wanted to examine. I even attempted to obtain the judgment, the actual judgment of the case from the courts, or you have to obtain them through the archives. And unfortunately, that even the order doesn't seem to, or the judgment doesn't seem to be within that file. So the entire, I have yet read the actual judgment in this case. So there's just a lot of things. So I believe there's a lot of issues within the case. Non-joiner of a necessary party impacts the validity of the proceedings, and I believe that there's substantial evidence to show that they misrepresented necessary parties in the action. So I'd like to thank you for your time. I'll go further into the book. I believe it's quite an interesting book. So thank you for your time.